2.9 Legitimacy of the Judicial Branch. So our courts kind of follow this judicial tradition that began all the way back in England. Okay, so first we have common law, which is like this body of court decisions that make up part of the law. It's not necessarily like written down by like law in Congress, but we declare these things to be like not constitutional, kind of illegal. Like if you do it, there will be consequences because of these court cases that happened. Like this is what the court decided. And then there's this thing called precedent, which is a ruling that firmly establishes a legal principle. And this is generally followed because subordinate courts, to like the court that set the precedent, they have to follow that court's precedent, and any of the other courts like around it or above, they're going to consider this precedent. And this concept of stare decisis, that governs common law, and that means let the decision stand. Now, there are two types of precedent, persuasive and binding. And binding precedent is basically the higher court ruled this, so a lower court has to follow it. They are bound to that higher court's ruling. So, like, if one of the appeals courts ruled on this, then all of the district courts have to rule that same way. This is different than persuasive precedent, which is when a court will consider past decisions in, like, say, other district courts or, like, far away circuit courts to, like, kind of guide them in making their decision. And precedent can also end up being overturned. And Supreme Court precedents, that establishes policy. They have, like, this total authority with the binding precedent, and the power of just judicial review makes it so powerful in establishing national policy. So, defining federalism. So the Supreme Court, very early on, it was kind of like this nondescript institution held in low esteem, as the book puts it. But really, it's more like, it was kind of just lurking there in the background, like, whatever. But, like, its role and reputation kind of changed. Obviously, the Supreme Court is not just lying in the back anymore, and John Marshall did a lot to help with that. He remained till death and helped create this united court, and he dealt with cases such as McCulloch v. Maryland, Gibbons v. Ogden, Marbury v. Madison, so he was this very influential dude. Now, continuity and change. The Supreme Court is known more for its continuity, because it has lots of customs that are established kind of just through overall consensus, and this remains constant over generations. However, the fact that they're like there for their entire life and they have this huge power of judicial review, that has people debating a little bit over its legitimacy, because they're like, that's a little too independent, similar to how Brutus felt. That's the anti-federalist. When we were talking about Federalist number 78, that's like what Federalist number 78 was responding to. Quick callback there. Anyway, the composition of the court changes as seats become filled and vacant, etc., especially because, like, these ideals will change with whoever's on it. And that can result in the overturning of some of these precedents, which creates those questions of reliability and therefore legitimacy. So that's kind of like a thought process for you. Now, overturning precedent. Like we talked about, rulings by higher courts bind lower courts to the same exact ruling. And then errors in the court's decision, however, can be corrected by Congress. Because, you know, Congress could then change its legislation to, like, fit the Constitution or change it in other ways, you know? And in relation to Constitution application, the court has often reconsidered and overturned its own ruling if they believe that ruling was made in error. An example of this is Plessy v. Ferguson, which that allowed separate schools based on race, so that allowed for segregated schools, one school for white people and then another for black people, but obviously, with Brown versus Board of Education, this was reversed because that then ordered the integration of schools. So the Supreme Court reversed their standing on that. Another example is with Govey v. Townsend. And so this was when African Americans weren't allowed to vote in the Democratic Party of Texas's primary. And they determined that the Democratic Party could set its own rules because it's a non-governmental organization. This was overruled in Smith v. Allwright then, dealing with an argument about the 15th Amendment right to vote. Here's a little quote for you. In reaching this conclusion, we are not unmindful of the desirability of continuity of decision in constitutional questions. However, when convinced of former error, this court has never felt constrained to follow precedent. Govey v. Townsend is overruled. And this is a very dramatic shift over 9 years. But by 1944, when this was ruled, there were different justices and there was World War II going on. So there was lots of changes in the world and happening. Now, the Supreme Court today. So the previous Rehnquist Court and now the current Roberts Court, they have been difficult to predict. And this is all from the book, so I don't know how accurate it is to present day justices. So it's kind of been balanced by the swing votes of O'Connor and Kennedy, and John Roberts is the Chief Justice, and he's kind of guided the court with judicial minimalism, and they've kind of taken on fewer cases and gone on a little longer with those cases. Thank you. I hope this helped. Please share with a friend, and good luck on whatever you're using this to study for.